We are joined now by our recurring legal analyst, legal affairs analyst, Robert Pallitto, Seton Hall University. Good to have you here. Bring us up to speed where we are, Supreme Court, looking at healthcare reform in the U.S.
Good morning. Well, last week we had 3 days of argument. It was kind of an unprecedentedly long series of arguments in the Supreme Court on the 2010 Affordable Care Act. And the court was looking at a number of questions. First of all, whether the case could be decided at all right now, or whether it had to be held off because of a law that addresses how you can challenge taxes in court. Secondly, the individual mandate, which is really the most controversial part of the law, the expansion of Medicaid, and then finally, what to do if part of the law is struck down. Could it be severed from the rest?
The biggest centerpiece, of course, the mandate. Where does that stand, as you see it? What are the legalities around that?
Well, there are two questions of constitutional law here. First of all, whether this is a proper exercise of the court's, of Congress's commerce power. In other words, Congress passed this law under its power to regulate interstate commerce. And then secondly, even if it is a proper exercise of the commerce power, is this a proper use of that power? So they have the authority to do it, but they do it in the right way.
Can you break it down to what exactly issue? What will the Supreme Court be deciding? Because this is a very complex topic that they're taking.
Well, on the individual mandate question, if they do reach that question...
An individual mandate means that all Americans would be required to purchase or have health insurance.
Right. So if you don't receive it through your employer or through a government program, you have to purchase coverage for yourself. And if you don't, you pay a tax penalty, which is assessed. It's not collected in any way other than that it's assessed against any tax refund that you would get. And the maximum comes out to about $700 a year.
So we're trying to see if this violates the Constitution.
Yes, whether this particular regulation violates the Constitution, either because it's not a proper subject of commerce regulation, which the opponents are saying, or secondly, that even if it is a proper subject of commerce regulation, that this particular way of regulating it is improper.
Isn't it kind of bizarre? This is something that was actually supported. It came out of, I believe, the Heritage Foundation, very conservative group that came up with this. The president incorporated it into his health care plan, and now it's the conservatives who are fighting it. And you have a majority of conservatives on the Supreme Court.
Yes. It is very odd, and you can see how much politics shapes the way that people view an issue, because you could view this as simply another way of regulating health care, which has been done in the states, as we know, including Massachusetts, or you could view it as sort of an unprecedentedly coercive measure by the government, forcing people to buy something that they don't want to buy. And when you listen to the arguments, you can see that the sort of conservative bloc of the court is looking at it in the more negative way, that it's unduly coercive. And the liberal bloc of the court is looking at it as just a regulation that's similar to other regulations that we already have.
As you're observing this, could you tell if the court was particularly concerned about any parts of the argument?
Yes. For one of the things you can see is that the two blocks, and the one block, the liberal block, includes Justices Sotomayor, Kagan, Ginsburg, and Breyer, and the conservative block includes Roberts, Thomas, Scalia, and Alito. And then Justice Kennedy is often a swing vote. We often see him sort of breaking a tie between the two blocks. But you could see the concerns from the conservative bloc, particularly that this was forcing people into activity when they weren't in activity before. In other words, some of the justices seem to be saying, well, you can regulate the way that people engage in commerce, but you can't bring people into commerce that they're not already engaged in, which is a little bit of a strange distinction because when you look at the healthcare market as something that we all are involved in at some point in our lives, it doesn't seem that strange or unprecedented that we would be required to participate in a certain way. But the way the justices, particularly Justice Scalia, are defining the market is buying insurance, saying that insurance is not the only way to meet our health care needs. So it's very much a question of framing.
Don't we already do this with auto insurance, for example? You're required to have auto insurance in almost every state if you're going to have a vehicle. Isn't this kind of the same, legally, is this the same thing?
That's really the way I see it. Some people would say, well, not everyone has to drive a car.
But it's a choice to drive a car.
Right. In fact, one of the justices said, well, if you live in Manhattan, it's likely that you don't have a car. But to me, that seems to be beside the point. I mean, many of us don't have a choice as to whether to drive a car, and there are many people who are struggling financially who pay for auto insurance that they can't afford because it's the only way they can get to work. So that's one issue. The other issue is that sometimes we look at state versus federal regulation, and auto insurance laws are largely a product of the states. So the opponents of the law could say, well, if a state wanted to enact this, they could, but the federal government can't. Well, that really gets us back into the question of commerce. If it's interstate commerce, which healthcare undoubtedly is, then it seems like it does bring us into the ambit of what the federal government can regulate.
Do we have any clue, and I know it's probably not a good idea to try and ever guess how a court is going to go, any indication how this may go and when we're going to find out?
It'll be a couple of months, I think. The court still has to conference the case, and then the opinion will be assigned, and then the opinions will be drafted. So it will be a while. It's very hard to say. It's a risky business trying to say exactly what's going to happen.
You never want to try and second guess what a court is going
Right.
to say.
And
Because you'll always get it wrong.
Sometimes too at who goes to the other side. We saw Judge Roberts do that in another case. So you never know.
Yes, and in fact, in Boumediene v. Bush, which is a very different context, it had to do with detainee rights and related to Guantanamo. The swing vote was Justice Kennedy, and Justice Kennedy ended up writing an opinion that went in favor of habeas corpus, in favor of individual rights. So it is hard to say. I think there are pretty solid blocks on either side, and I do think Kennedy will be the deciding vote.
So we will just have to wait and see. Thank you, Professor,
Thank you.
for taking the time to talk to us today.
Always good.